And joining us now is Professor Sherif Girgis from Notre Dame Law School to talk about his latest law review article, something we don't say that often on this podcast, which is titled Originalism's Age of Ironies, coming out in the Harvard Law Review. I want to kind of just start at the beginning of the beginning. Can you give us your brief history of originalism and how we kind of got to this moment to begin with?
Yeah, at least as a modern thing, so bracketing whether it was used way back. I think of it as first, in Robert Bork's form, a reaction to the Warren and Burger courts and the idea that they were both lawless and unfaithful to the founding. So we got to go by the founder's intent. Then over time, people were like, oh, what's the intent of a multi-member body and how do we know? And besides, what was in their heads didn't become law. So what we should really do is go by the original meaning, which is objective and you can read it. And then over time, it turned out that in a lot of cases, original meaning runs out or it's not clear. And so more recently, there's been a lot of supplementing with other stuff. The original methods of interpretation, if that gives you a tiebreaker in some cases, the context, which is kind of loose and in different people's hands means different things. And that's kind of where we are now.
If originalism is supposed to be a constraint on judges, right? I mean, this was the reaction to Warren and Burger, that they were unrestrained and simply sort of these 9 platonic guardians up on a hill on 1 Street, divining what would be good for the country. And so originalism conceived as this restraint on judges. And I guess here we are in 2024. And is it a restraint?
Yes and no. So I think there were 2 threads from the beginning. There's a great piece by Joelle Alisea, who's been on here too, in City Journal, that goes into this a little. I think there were kind of 2 threads. One was judges are not king here, the people are. So we need to find something to tie their hands. And here's something, the original something. And the other thread
mumble.
Exactly, et cetera. And the other thread was a little bit different. It was, what has authority in our system as higher law? It's the original meaning. Like that's the way to figure out what counts as higher law around here. And the 2 things can come apart because it could turn out that the original meaning is super vague or broad. It could turn out in some cases that the original meaning actually tells interpreters to consult their moral judgments. So some people think the cruel and unusual punishment clause is a little bit like that. So over time, what you find out is that when these things come apart, different originalists take different tacks. And that's kind of what this piece is about.
One thing that I thought was really helpful about this piece was you divide out traditionalism from originalism. And traditionalism is something that can look like originalism. It can sort of from the outside. So what is traditionalism as distinct from originalism? And what are some cases or examples that you would point to as traditionalism versus originalism?
Yeah, so I've defined traditionalism basically by negation. So it's the uses of traditions, which I think in practice usually means political practices rather than judicial precedents. So what have Congresses and presidents been doing? What have state officials been doing, either state legislatures or state courts? So that's one part of it. It's that, not judicial precedent on point. And the second part of it, again, I define it by negation from originalism just to make it clear where there might be tensions. And I think of it as the reliance on those things, those practices, that it's kind of hard to justify from within originalism. So one way it's easy to justify reliance on practices is if it's incorporated by the original meaning. So if, so a lot of rights provisions are supposed to be like that. Like the court says in Heller, the Second Amendment codifies a pre-existing right that's constituted by practices leading up to it. All right, that's easy. Second, early practices. So the idea there being that if, the Congress that gave you the Establishment Clause immediately turned around and led its sessions with legislative prayer, that probably means it's not inconsistent with original meaning. Judicial precedents, originalists have a theory of relying on that. So if you count that as practice, it's covered. And then the last kind of tradition, and I think this is a little subtle, it doesn't get distinguished enough, is what a bunch of original scholars like Will Bode call liquidation. And
I'm so glad we're talking liquidation.
I want to talk
yeah, it's at first you hear it and you think like all items must go. Like it's not that. It's something else. I think of it as it's supposed to be the closest thing to judicial precedent, but on the political side. And that's the way that Madison seems to talk about it in Federalist 37, I think. So he says, look, when a constitutional provision is vague, and it's inevitable that it'll be vague because language is limited, and this is like 4,000 words. It's basically like a long article. When it's vague, you have to do something. And sometimes we defer to the decisions of judges because they hashed it out. They tried to get the right answer. And we don't want to disrupt too much. So to balance, having the law settled right and having it just settled, we'll defer to past judges. But it turns out you can do the same thing with non-judges. So Marshall talks about this in the case about the National Bank, McCulloch versus Maryland. He says, look, I'm not coming to this with a clean slate. Other actors before me have hashed it out, namely presidents and Congresses, and they fought over it. And then they reached a settled kind of practice of saying, we're going to have the National Bank. And I can defer to that too. But I think there it's crucial, and I think this shows up in Madison and in Will Bode's gloss on it. It's crucial that there actually have been a debate about it. Like you have to imagine that Congress and the president hashed it out and thought about the interpretive issue and then settled on an answer. It can't just be a practice they backed into. And this is true with judicial precedent too. If a court decides a case, but it never talks about whether it had jurisdiction in that case and the parties didn't brief that, nobody seemed to pay attention to it, we don't treat that case as precedent saying that you have jurisdiction in those cases. We say, because, for all we know, they never thought about it. So you can't really balance having the law settled and getting it right if those past actors didn't even try to get it right. So I think if you're going to be saying that reliance on tradition is justified by originalism as a form of liquidation because the founders thought you could do liquidation, it needs to be practices that you have evidence that they debated. And in a past article, look at me, I'm already such a good academic, constantly citing my past stuff. In a past article, I talked about liquidation. I looked at all the cases where the court cites long post-ratification practices. So these other rationales we talked about don't apply. And where it says sometimes this is okay because it's liquidation. I think I found like 60 cases and maybe 3 or 4 of them involved actual evidence that there was a debate about the interpretive issue, and every other case doesn't. So to go to your question finally, the part of Dobbs that says, we're looking 100 years after ratification all the way till Roe v. Wade, and all these states massively regulated abortion, so it must have been okay. They're not showing that. They don't point to evidence that the states thought about whether the 14th Amendment let them do that. Or right. If, in a lot of cases where, like in NFIB versus Sebelius, Obamacare, the court says you can't compel commerce, in that case, have the individual mandate to cover, to buy insurance in the name of regulating it. In other words, that goes beyond Congress's power under the Interstate Commerce Clause. And part of our evidence for that is that Congress has never done it before. Well, unless we have evidence that they thought about it and they decided it would be unconstitutional, they hashed it out, that probably shouldn't carry that much weight. Anyway, so they do it in a ton of rights cases and structural cases. I'll give you one more example just to make it vivid. In, I think, 2020, 2022, I think it was the same term as like all the big cases, Bruin and Dobbs and all that. In a case called Houston Community College, a unanimous opinion by Justice Gorsuch said it's okay under the free speech clause to sanction public officials for their comments, or to sanction, like, I don't know, I think it was like members of local school boards or something for their comments of XYZ sort, because local school boards have been doing that for a long time. And some of his examples were from 2020. So long after ratification. And there was no evidence that they had hashed that stuff out. So I think that's what I call living traditionalism.
Yeah, I'm so glad that you brought up this the discussion of these legislators, because this is something I've been talking about for a long time. these guys are not interpreting the Constitution as a general matter. Now, we might find some evidence from some debates in some places that the 14th Amendment came into play in the discussion. But the idea that these state legislatures or town councils or however low you want to go were dealing with the 14th Amendment and wrestling with it just strikes me as fantastical. But let me also ask you this, Sherif. Since legislatures are not tasked with interpreting the Constitution, how much weight should be placed on, even if they were debating the 14th Amendment, how much weight should we place on their interpretation of the Constitution?
Yeah, so I think partly it depends on how much we're judicial supremacists and how much they are judicial supremacists. So I think a lot of originals will hear what you just said and say, whoa, 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 at least the other branches are sworn to uphold the other federal branches are sworn to uphold the Constitution too. So they have an obligation to consider it. It's not just the court's job. Maybe it's even a co-equal responsibility just within their own domain. The president needs to make sure that what they're doing is constitutional. Congress should do the same. And so actually we should give it weight. But then you run into and maybe that was true a long time ago. Like you do see debates in Congress about the national bank, about whether it's constitutional, and with presidents. But I think over time, partly because we've come to think it's mainly or only the court's job to interpret, the legislatures have been doing that less and less. And the less they do it, maybe, as you're saying, the less we should defer to it, even if officially in the abstract they had an obligation to do that too. And you hear lawmakers say, on both sides of the aisle, well, we'll pass it and let the courts figure out if it's constitutional. Well, if they're doing that, then they're telling you they're not doing con interp before taking their actions, so you shouldn't give it much weight.
Wait, I just heard a term, con interp. I love that.
Constitutional interpretation.
No, I'm gonna appropriate that. I'm gonna use that. Con interp. No, I love it.
It'll save time on this
the podcast. Yeah, that's a hard no from me. Can we do little originalism baseball cards for each justice? So I just want you to give your one sentence view of their judicial philosophy and where they sort of fall on a maybe originalism 1 through 10, liquidation 1 through 10, traditionalism 1 through 10, or whatever, scale you want to use.
Yeah. So, okay. Let's start at the top or the bottom from the originalist perspective, depending on what you think. So I think Chief Justice Roberts has it as one tool in his toolkit. I don't think he thinks of it as controlling. He's not that theoretically self-conscious in his opinions, at least. He's not telling us a ton about method. He's not writing separate opinions about method, etc. All right. Justice Alito describes himself as a practical originalist, which I take to mean, we should go by original meaning where it's clear and controlling, but we should not give an originalist argument much weight if it leads to crazy outcomes or if it's contrary to precedent. Maybe his threshold for just going with a precedent is lower. He's quicker to do that. Justice. Okay, now I'm taking myself out of the ranking game. I'm just going through them. Justice Kavanaugh, I think, is a kind of old school Bork-like originalist. So he's more at the earlier phase of what I described. I mean, he goes by original meaning. But one of his big reasons for going by original meaning is that you should tie judges' hands. And so when the original meaning runs out, he's looking for something else to tie judges' hands. And that shows up in his Rahimi opinion, where he's like, look, when the original meaning and precedent run out, you have two options. You can go by policy reasoning, which is illegit because you're a federal judge, or you can go by history of some kind. So it's not early history, so it's not neat and tidy, but it's still history. And which means it's still, because it's political practices, the people's will, not mine. So I'm going to grab onto that. I think Justice Thomas does the same thing, though he doesn't talk about it in those terms. And Justice Gorsuch might tend in that direction too. And then you have Justice Barrett, who I think of as having, in a sense, the most theoretically pure originalism, but ironically, it turns out to be less constraining. So she says, no, I'm only going to go by history if it's early history, so it tells about original meaning, or if it's incorporated by the provision, like the pre-ratification history with the Second Amendment. But otherwise, I'm not just going to pick history from like some state legislature in the 1940s. So if I'm not going by that history, I jump more quickly to judicially developed tests. And since those tests are going to have to govern a really wide range of cases, they're going to have to be pretty general and use words like reasonable. And even if that means judges are going to do some policy reasoning, get over it. Like there's no other option.
You hear a few echoes of that. And when Justice Gorsuch talks about this is the role of judgment, that at some point you're going to reach a level where the history, the tradition, whatever you want to say, it is just not going to provide some sort of like digging for gold. You found the buried treasure that contains the exact specific shining golden meaning of the statute or the constitutional provision. And at some point in all of these approaches, you exercise what Gorsuch calls judgment. And I guess it's how wide or small that arena of judgment is.
I think that's right. They disagree about how quickly you get to that stage.
Mm-hmm.
And they disagree about whether you should still try to reach for something that's not your own opinion about what's reasonable when you get to that stage. And that goes to the role of post-ratification history for Kavanaugh versus Barrett, for example.
Yeah, so let's dive in on Gorsuch, Kavanaugh, and Barrett. Because in a case like Bostock, you have Gorsuch and Kavanaugh on opposite sides. And you have Gorsuch, I think, really eschewing some of those originalist tools because I think his is sort of a cascading set of rules. So like, first look at the text. Is the text clear? Yes. Go no further. And so he is sort of textualist first, originalism second. And if originalism runs out, so be it. Then we're done. And I'm wondering if you can compare Bostock and what we learned about the two of them to Rahimi and what we learned about the difference between the three of them.
Yeah, so I think that's right. In Bostock, it matters to Justice Kavanaugh that nobody thought that Title VII barred discrimination based on sexual orientation or gender identity for like 50 years after the Civil Rights Act was passed. And he just thinks if your originalism or textualism in that case is leading you to an outcome nobody thought was supported for 50 years, you're doing it wrong. Like whatever the theoretical niceties are, you got to go back to square one. And then he still ties it to the text. He says, if you zoom out to the whole phrase, discriminate against because of such individual sex, you're going to get the vibe that it's about misogyny or about unfair attitudes or assumptions about members of a particular sex. And whatever you think about sexual orientation or gender identity and discrimination, it's not like that. Whereas Justice Gorsuch is like, look, the expectations of people for 50 years are not in the US Code. The words are. So I'm just going to go by that no matter where it takes me. And then in Rahimi, I think the back and forth is basically like this. It's Justice Kavanaugh says what I said earlier, which is when original meaning isn't super clear, it just says the right of the people to keep and bear arms. It's pretty general. You should go by, you're either going to have history or the judge's own policy views. And I want to go by whatever history it is, even if I don't have a grand theory for why it matters, rather than policy. So he's willing to look long after ratification at what people were doing, even if they didn't debate the constitutional issue, the counter-interp issue, et cetera. All right. Justice Barrett says that stuff is not law. So we just have to own the fact that we're going to have to create judicially managed tests. Justice Kavanaugh would come back at that, I think, and say, well, look, it might not be law like con law that was ratified as by the Article 5 process, but at least it's better than judicially managed tests in terms of popular sovereignty because it's political practices. And I think Justice Barrett would basically say that's not true. So on one interpretation of Bruin, for example, the fact that nobody long after ratification passed a law means that you can't pass it now, a gun law. And I think Justice Barrett would say to that, well, that's not actually popular sovereignty because that is taking one legislature's ordinary lawmaking or their lack of lawmaking and tying all future legislatures' hands by that when it was never actually made higher law. So you're actually dishonoring the popular sovereignty of all future legislatures by tying their hands by what the past one happened to not do. And if you come back at her and say, well, you've got, now you're just going to your own judicially managed test of reasonableness, what legitimizes that? And I think she says it's inevitable. She says this in actually a free speech case from this term called Vidal, where she says, look, with a broadly worded right like the free speech clause, it's inevitable that you're going to run into a case where you don't have a historical analog. And she thought Vidal, which was about a trademark restriction, was one such case. And so she says, once you hit a case with no historical analogs, you're going to have to do something else. And basically, this is the only option. So going by historical analogs in the meantime, it doesn't just lack a theoretical basis. It's just delaying the inevitable. And if you don't like having judges create broad general tests to implement broad rights, you shouldn't have ratified a broad right in the first place.
So since I feel like now I'm getting to talk to AI Justice Barrett and AI Justice Kavanaugh,
Yes.
I've got a question for them.
Yeah.
Judge Wilkinson over on the Fourth Circuit, when ruling on an assault weapons ban, made the point that mass shootings weren't a problem at the founding, that they weren't very good at killing lots of people. You were maybe better off with a knife even. And that so it shouldn't be any surprise that we don't see legislators doing that kind of debate or that type of legislation in this early post-ratification or pre-ratification history, because the problem didn't exist. And so originalism, properly conceived, for him, would need to wait until the problem. And this is what I've sort of referred to as the horizontal problem with originalism right now. There's the vertical problem of the level of generality of the analogy that you're trying to find. That's the Rahimi problem of what those laws at the founding, were they just, as long as we were concerned about dangerousness and dangerous people, that's a good enough analogy to what 922G and all of its iterations are. So we're good on the Second Amendment. Vertical. Horizontal is this time frame of what we're looking at for the history and tradition. And Wilkinson's point is, why would I look to, immediate post-ratification history on elephant stampedes if there were no elephants? But in 1920, someone brought over a herd of elephants, and all of a sudden you see elephant stampeding laws popping up in all these sorts of different states. And that's what sort of happens when Tommy guns and machine guns and guns that can mow down a lot of people start appearing on the market. So AI Justice Barrett and Justice Kavanaugh, what do you say to this horizontal issue?
Okay, I think AI Kavanaugh would say, exactly. And that's another reason, another arrow in my quiver, if that's the thing you hold arrows in, that justifies looking long post-ratification. Sweet, I'll take it. And I think Justice Barrett would say, that's not enough. So it's not enough that you find something that looks the same a little bit later. It needs to have legal relevance. And when we're interpreting higher law, ordinary lawmaking doesn't have that. So just because it would tie your hands or it looks similar or it looks kind of relevant doesn't mean that you get to rely on it. Like if you flipped a coin, you'd be tying judges' hands every time because they could have no policy reasoning. They just do heads for the plaintiff, tails for the defendant, or for the claimant and the government. But that doesn't have legal authority. And this is a less egregious version of that. I think basically I think what Rahimi shows, because there's a little bit of revision of Bruen and Rahimi, I think.
Just
a little.
Just a
little or a lot. I'm trying to be charitable.
If you ask Judge Ho, there's a lot.
That's right.
And Judge Thomas.
Chief Justice Roberts is great at writing things in a way that's like, nothing to see here.
Yeah.
And so Bruen was about historical analogs and, whether there's a historical analog in our regulatory tradition. And Chief Justice Roberts in Rahimi says, no, Bruen was about the principles underlying our regulatory tradition. And principles sounds broader. So that's supposed to capture, even if you stick to original era, that's supposed to capture the stuff the problems that they didn't care about yet, but that somehow there's a principle for. But I actually think you're just going to hit a dilemma So either you're going to look for, if you're really trying to do narrow principles, which even Justice Barrett says you should try to do, because if it's too general, you might dilute the right. You're either going to look at narrow principles that are like shrink wrapped to fit the regulations around the founding era, but in that case, you're going to cripple the state's ability to regulate for new problems too much. Or you're going to shrink wrap your narrow principles to fit the explicit, the conduct that was explicitly discussed as protected in the past. But then I think you're going to shrink the right too much for, at least for this court's purposes. So either way, narrow principles are either going to limit the state too much or limit the right too much, and you're going to have to go more general. And that more general approach is going to run right back into the kind of balancing that conservative judges feel uncomfortable doing. But I don't think there's really an alternative when it comes to open-ended rights. Because think about it this way. Why would you go for an open-ended liberty as opposed to a more specific constitutional right? So take, in the case of religion, take like the ban on religious tests for office, which sounds like a ban on just a very specific kind of regulation, regulation that says you have to be Anglican to be, dog catcher, versus a really open-ended thing like the free exercise of religion. The whole point of the second approach is so that you capture a lot of different kinds of regulation, including ones you don't foresee now. So you couldn't name them to forbid them specifically. But by the same token, you also can't foresee whether the right is going to be, if it's applied categorically, is going to block regulations that we really need in the future, or that we now think we really need when we didn't in the past, like domestic violence regulations in Rahimi. So basically the very reason to go for a broad liberty as opposed to a specific right, free exercise rather than ban on religious tests for office, is also the reason that you're going to have to end up doing something like balancing as you apply it over time.
Yeah, I'm glad you said that, because as I was looking at the 8-justice majority in Rahimi versus Justice Thomas, which just so amusing to me, and it's so funny that you have 8 justices saying, no, you misunderstood Bruin. And then you have the actual author of Bruin going, no, the writer here.
Yep.
Yeah. Hey, I meant what I said the first time. But what strikes me is you really do, when you read the difference between Thomas and the other 8 justices, it just looks like a different test. So it looks very much like a text, history, and tradition version of strict scrutiny versus a text, history, and tradition version of intermediate scrutiny. With the strict is you got to find the match. The surety laws are the way. And then, the 8 justices saying, no, you got to find the principle. And the principle is dangerous persons can't possess a firearm. And
exactly.
And that, as you were saying, it just seems difficult to find any way that doesn't at some point get down to that balancing, whatever you want to call it, tiers of scrutiny versus levels of specificity.
Yeah. And I should say, I'm sympathetic to the motivations of the Justice Kavanaugh view. Like, I think, if you've clerked on any court, but especially on a court that can change the rules midstream and change its own precedents, you get, or at least I got, this very vivid sense that, like, hey, who made you king? You can't just do that. You've got to, we have to find a way to limit what you get to do. So I'm fully on board with the motivation. I just think that it's going to run into problems by design, even in court cases, when it comes to some rights, like the open-ended rights that you get with speech, religion, and guns. And that's why you see these debates popping up in cases like Vidal, which is speech, and Rahimi, which is guns, and the most, the kind of COVID era regulations of worship. So that's free exercise.
Okay. Last question. It seems to me that what we're sort of talking about and what the justices are debating is several feet down the originalism hole. Sort of everyone's agreeing that you look to the text first. Sure, we're having some debate between Kavanaugh and Gorsuch of how much you include sort of what that meant to people at the time versus what the text means to us now, but we're definitely looking at the text. everyone's an originalist to some extent. What happens when the originalism as we conceived it runs out? That's where we're sort of at now. But I think my question is, what is the viable alternative? Not within originalism world, not within these fights, but really on the left at this point, because it feels to me like nobody is really defending living constitutionalism anymore. And legal realism has become maybe descriptive. Judges are just doing politics by another name, maybe descriptive, but it's not a judicial philosophy. Nobody's out there saying, I'm a legal realist and I just do what I want. So aside from these debates, what's out there that someone can pick from?
Great. So let me say something about the first part of the question too. I think, even though we're talking about the limits of originalism and the divergent paths you take when you hit the limits based on what motivated you to be an originalist in the first place, et cetera, et cetera. Okay, great. I think this shouldn't be too shocking or scandalous. I think it's basically what happens when originalism goes from the opposition party to the governing philosophy.
Totally.
Because when you're in opposition, you get to just talk about the cases where your method has a strong answer, a strong view. But when you're running the show, you have to talk about all the cases on the docket, including the ones where it kind of runs out. Another thing is that when everybody knows there's an originalist court, then the side that clearly loses under originalism is going to be less likely to take its case to the court. They're just going to accept defeat in the lower courts because they know it'll be a waste of time. So maybe the fact that it's an originalist court, on the one hand, means that originalism is less likely to decide the cases that get to it, ironically, because they'll be the close ones. But on the other hand, might still be doing work just by blocking cases from coming to it in the first place, because if they're clear by originalism, they're not going to get there. Okay, so that's, I think, why we're hitting this. And it doesn't mean that originalism is doing no work. I think it means that it's going to be harder to use as a positive philosophy than it was as a critique on the apex court in particular.
Right.
All right. And then, so even when it hits its limits, as you're saying, you got to judge it not only by how it does when you hit those limits, but also by what the alternatives are. And you're also right that people don't generally defend living constitutionalism by those terms, because originalism has enough rhetorical authority and political potency that in a general way, like people get it and like it enough. That's why no justice or no judge, when they're up for confirmation to the court, says I'm a living constitutionalist. If you look at academics where they don't have to pass through a confirmation hearing, I think the dominant thing you'll find is what they call pluralism, which basically means there's a bunch of different factors, but there's no special hierarchy. They'll rarely say the original meaning was clearly X and we're going to go against X, but they might be quicker to find the original meaning ambiguous, or they might be quicker to stick to precedents that they like and that are not obviously originalist. And then in other cases, they're just going to say you have to do it in a kind of context-sensitive way. You have to look at values and consequences, and you have to look at principles of fairness and precedent and original meaning and political traditions, even if they're not clearly justified by original meaning. And that it's either bad because you'll sometimes reach crazy outcomes to give the original meaning or the plain text or whatever a kind of trump card, or it's unrealistic, or it's never what we've really done. So obviously in practice, if we've always done pluralism must be okay. But it's not a neat and tidy theory. And I think that's part of why it doesn't have the rhetorical force and the kind of lowercase p political authority that originalism has.
You could never teach someone to practice pluralism as a judicial philosophy, and no two pluralists, I think, would end up in the same place based on purely that judicial philosophy. Pluralism sounds to me a lot like, look, hire smart people as judges. Thoughtful, wise people as judges. It's a little bit of the Breyer model.
Yeah, exactly. But it's also, they don't want to say anything goes right now because they don't like the political moral judgments of the people in charge. So I think that's why you're finding, to the extent that there is a kind of politically potent push against the court, it's not really about pushing an alternative, clean and tidy method. It's more about just saying, have the court do less by, so it's a kind of judicial restraint thing, which is where the conservative legal movement was in the early 80s. Or it's a mix up the political morality of the court by adding other justices, have them do less, not just by judicial restraint, which means a kind of deference to political actors, but also by stripping them of jurisdiction, so having them not even take certain cases at all. And in the worst case scenario, from my perspective, just try to delegitimize them so that they feel less free to do what they think their theory requires, or whether when they do that, it has less authority in the public square.
Sherif Girgis, professor at Notre Dame Law School, with his new law review article out, Originalism's Age of Ironies. Thanks for joining us.
Thanks,
Sherif.